Welcome to this Mishcon Academy digital session. My name is John Sendama. I will be chairing this session for Black History Month at Mishcon Dereya, where in a series of 4 sessions, we are exploring the theme colonial amnesia, a legal and historical review of the afterlife of Britain's rule in Africa. This session is entitled Operation Legacy, Empire, Archives and the Law. Here we are looking at how our image of the British Empire has been shaped by the destruction and concealment of colonial records and the broader issues that this raises. We're exploring these topics through the lens of the Muthoni case brought in 2009 in the English High Court, which is also known as the Mau Mau litigation. In the case, 5 elderly veterans of the Mau Mau rebellion, which took place in Kenya between 1952 and 1960, brought proceedings as representatives of a much larger group against the Foreign and Commonwealth Office, seeking damages for extreme acts of violence and torture suffered at the hands of British colonial forces in Kenya. During disclosure on the case by the FCO, an archive of 300 boxes of previously undisclosed documents came to light, which supported the allegations of widespread human rights abuses and torture perpetrated by colonial officials in Kenya. The documents also confirmed a systematic program of document destruction during the process of decolonization. The case resulted in a successful settlement for £19.9 million for the claimants and several thousand other Mau Mau survivors. I'm very excited and honored to introduce our phenomenal panel, each of whom played a critical role in the case. In speaking order, our first panelist, Dr. Muthoni Wanyeki, is Regional Director of the Open Society Foundation's Africa Regional Office. She's also held a number of significant positions, including Regional Director for East Africa, the Horn, and the Great Lakes at Amnesty International, and Executive Director of the Kenya Human Rights Commission. Muthoni is a political scientist, human rights activist, and journalist who worked closely with the Mau Mau War Veterans Association and the Mau Mau survivors for many years in their fight for justice and their efforts to correct the historical record in relation to their experiences. Our second panelist, Professor Caroline Elkins, is a professor of history and African American studies at Harvard University. She's also a Pulitzer Prize winning writer for her first book entitled Britain's Gulag, The Brutal End of Empire in Kenya, as it's known in the UK. The book also goes by the name Imperial Reckoning. Caroline's research was the foundation for the Muthoni claim, and Caroline has served as an expert witness on that case. Our final panelist, Richard Hermer QC, is a barrister at Matrix Chambers, where he specializes in public law and private law litigation in both domestic and international matters. He's acted in a number of notable private international law claims brought by claimants from overseas in the English courts against multinational corporations in relation to human rights abuses and widespread environmental damage. Richard also lectures extensively in the UK and internationally. Richard was lead counsel for the claimants in the Muthoni case. I'm now pleased to hand over to Muthoni, who will be discussing the genesis of the Mau Mau survivors' efforts to seek justice.
So I would say there were several streams that came together to enable the case to happen. I think the first stream was the Mau Mau veterans themselves, who had been banned and hadn't been organized until our quote unquote political transition of 2002-2003, when they were unbanned. At which point they began working with the Kenya Human Rights Commission, which I headed soon after that. But what the commission was trying to do was set up a process of transitional justice for all victims, survivors' families of mass atrocities initially in the Kenyatta 1 and Moi eras. The Mau Mau became a group that had claims that went before independence. So the KHRC was working with them to sort of articulate what those claims could be. in a transitional justice process, which the chair of the KHRC was heading the task force set up by the transitional government to explore. The second stream, which was long-standing, was the stream of work done by a former colonial district officer, John Nottingham, who was instrumental in the case. He had, during his service in the colonial era, been very uncomfortable with what he had seen in terms of land removals, in terms of treatments of Kenyans and so on. He settled in Kenya, married in Kenya, and had spent a considerable part of his life trying to explore what had happened to documents he knew because he had served within this service that had been destroyed at the time. He became a point person for Carolyn, but I will leave it to Carolyn to talk about that. Became aware that the Mau Mau were organizing under the KHRC and happened to bump into Martin Day. I shouldn't say happened to bump into, sought Martin Day out, who happened to be in Kenya pursuing claims against the British Army for abuses in the north of the country in the Samburu territory. So Martin was introduced by John to two Kenyan human rights lawyers who then introduced them to the KHRC. And out of that, the idea of some sort of case that would involve Lee Day, Martin Day's company, the KHRC and the veterans came together. So that's roughly what happened. And coincidentally, we had reached the period of end of disclosure of official documents from the colonial era. Carolyn's book came out at the same time or round about the same time as David Anderson's book, Histories of the Hanged. They took very different approaches, but Carolyn will speak to that. So we had the beginning of archival work and work with survivors on really documenting what had happened within and exposing what had happened under colonial rule. So those were the different streams that sort of came together initially.
Thanks, Muthoni. Caroline, I'd like to hear from you in relation to your experiences, your research and your experiences on the case.
Thank you, John. And first of all, thank you for having me here today. It's an honor and a privilege, and to be back with my colleagues and dear friends, Richard and Muthoni. It really makes this quite special for me, and also an opportunity to really reflect a little bit more as time has passed on the nature of the case and the role that historians, who are so often just kind of these lone wolves sitting in archives, writing books that they hope their mother will read, to having a project that had significant meaning outside of the world of academia. And I should point out that, insofar as the history of Kenya or modern Kenya, or even the history of Mau Mau, it was one of the biggest fields that historians and other scholars had written on outside of, certainly in modern Africa, outside of apartheid South Africa. And in the 1990s, when I began this project as a graduate student, I was strongly dissuaded from undertaking the project. And sort of two main headlines. One was, there's not enough documentation to do this, you're not going to succeed. And the second one was, this is a political hot potato, not a good idea for a young graduate student to be tackling this. Of course, me being me, that was all the reason, both of those, to undertake this. But of course, those warnings did prove correct in different ways. And, on the documentation, you gestured to this, John, as well as you, Muthoni, that there was clearly the knowledge that vast amounts of documentation was missing. And it was once I got into this that I began to understand the extent of that. And, I think there was certainly reason why at that time, nobody had written sort of a systematic analysis of these detention camps. Yes, there had been references to them for sure. There was, typically those references would talk about the official 70 to 80,000 detainees who are held in the detention camps, also known as the pipeline, sort of connoting the increasing and decreasing nature of severity of the camps, depending upon a detainee's level of cooperation. But there was also the sense that aside from one-offs, and we can talk about these, you know, the most famous of which being Hola in 1959 was seen as being an exception to an otherwise successful campaign of liberal reform, also known as rehabilitation, where they were taking so-called Mau Mau savages and reforming them and making them into sort of middle-class modern citizens behind the barbed wire of detention. And, you know, sort of to accelerate some of this, you know, as we know, all good purges leave something behind. And so there's nothing like a graduate student, and I was quite privileged. I was here at Harvard for my graduate studies, and I had a lot of money, research money, and a lot of time to undertake my research. And it unfolded over the course of several years. And what this entailed was literally going through file after file after file, asking the question of what were these camps about? Who knew what? And as my research unfolded, it became clear to me that my initial hypothesis of, yes, these were camps of liberal reform was really turned upside down. And once I began to reformulate that, many of the bits and pieces of evidence that I found that just weren't making sense, they weren't adding up, suddenly it all came into line. If you sort of suddenly abandon the view that this was all about sort of rehabilitation with, you know, sort of, as they said, some bad apples, to this is a history about systematic violence and cover-up, then you have this sort of aha moment. And that's when I realized, to the second point, but oh my goodness, yes, this is a political hot potato. But the evidence was accumulated in many official archives in Britain, as well as in the National Archives in Nairobi. And I also did interviews, hundreds of interviews with former detainees, as well as women in particular who lived in villages, what we call emergency villages. And I know we'll talk about this some more, but that 70 to 80,000 number in the pipeline really becomes quite erroneous when one recognizes that that number was quite misleading insofar as it was closer to a few 100,000 in the camps, but the women in particular were detained in what were called emergency villages, which were detention camps in all but name. So what we found out was that nearly 1.5 million Kikuyu, nearly the entire population, were detained in some form of detention. I want to make just a couple more points on this, and that is the challenge, my challenge, which I think eventually, and I'll let Richard speak to this because I'll keep coming back that I'm the historian and not the lawyer, and that's Richard and Muthoni. But insofar as our work is very similar, and I always say that historians are often frustrated lawyers and lawyers are often frustrated historians. So we get on quite well together because in many ways we're after documentation. We want to know if something is a fact or an act or it's not. Historians are a little more comfortable, often much more comfortable in the realm of the subjective. But in a book like this, one has to, one is basically reconstructing history to bear witness, to establish something that happened was fact, right? And so therefore what I was up to and what, these two very important and famous attorneys were up to was to prove that something happened, right? And so what becomes important for me is to establish not that these were sort of a series of one-offs, but that it was systematic. And there was a particular document, a 1957 document that was found that I found in the public record office at the time, now the National Archives, that actually had been sitting there for a little while. That had been overlooked, I think, by other historians, in part because they weren't asking the questions that I was asking. And that document was a document from Governor Bering to the Colonial Secretary with supplements from the Attorney General, Eric Griffith Jones, which really laid out something called the dilution technique, and we can talk some more about it, which was the point is a clear causal link between what was happening in Kenya, both the knowledge and approval of systematic violence, and when they learned, that is those in London, that the systematic violence was resulting in deaths and serious torture, they did nothing to stop it. Rather, they made actually incredible efforts ex post facto to create legal mechanisms to protect those in the British colonial administration who were perpetrating these crimes. And when my work came out back around 2005. There was a fair amount of criticism, a lot of disbelief. I think as Muthoni gestured to, my work came out at the same time as Dave Anderson's, which were quite complementary. I was asking different questions in many ways. I was quite interested in what was happening in these camps and in these villages. And as I said, that it was systematic and that there was cover up. Dave was looking at the aspect of extrajudicial hangings, quite important. The largest number of those who were sent to the gallows in the empire happened in Kenya during this period of time. So it's sort of a wider system of extraordinary and systematic violence condoned by the British colonial administration. And so I'll sort of pause in a moment, but at this point, what we see happening when we then sort of come together, and back to what Muthoni was saying, one of the big connectors in this is sort of as an historian, you look back, is John Nottingham, right? I knew John very, very well as a graduate student all the way up until the time of John's passing a few years ago. And, you know, as an historian of Kenya, you always knew when you got to Nairobi, the first person you went to find was John in the Trans-Africa building up on Kimathi Street. And that's what I did. And the moment John found out what I was doing, working on, his eyes lit up. And he became somebody who both, you know, he was a kind of gentleman that had a light touch insofar as working with a young historian, and who was fiercely determined that the ways in which I was establishing fact were going to be used for something much greater than myself. And I actually didn't know that at the time until we all met with, I was with John when he met with Martin Day many, many years ago. And ultimately what happens with this case is that on the, getting back to the criticism, is that this book in itself, in some ways, it was a unique case, as many reparations cases are. It's about putting history on trial, right? And it's about determining whether or not sort of what I found as a revisionist historian and what Dave Anderson contributed, and as well as Hugh Bennett, whether or not that was fact, whether or not that was powerful enough to overcome what had been traditional views, longstanding views about the nature of the British Empire as being a purveyor of reform, the civilizing mission, et cetera, et cetera. And so in this case too, it really put us to the test. And in the judge's courtroom, there was no room for academic bluster and critique and all the rest of it and all the posturing that we do as academics. Again, it was a fact, it was an act, or it wasn't. And I think in that sense, and here I'll sort of turn it over to Richard, the courtroom itself became a moment of historical unfolding, because those documents that you referenced, the hand-sloped disclosure, provided an immense amount of written evidence, which are the attorneys needed for this case. And at the same time, for somebody like me, it supported, tens of thousands of pages of documents supporting the claims of systematic violence that I had made in my book. And so in this sense, I feel as though, and I'll sort of stop here, and that is, it was an incredible privilege for me to be part of this case, learning a great deal about the ways in which history can be relevant in the present, and also the ways in which we took the lead from the claimants. And when one looked at their courage, and I was discouraged many times. I didn't have tenure at this point, all kinds of things. Don't get involved in this case. How could one not? And I think it's incumbent upon us as privileged academics to lend our knowledge. And I think in that sense, also to grow as individuals as we try to, really revise the past and the present and understand how it is we came to be today based upon processes, systematic processes of racism, of discrimination, of violence that impacted the way in which our systems and structures continue to be that way in the present day. So I'll pause there.
Thank you, Caroline. I'd like to hand over to Richard. It would be good to hear from you about your reflections on the case now that some time has passed.
Yeah, well, I start off by echoing Caroline. It's great to get the band back together. I came into the case later than Muthoni and Caroline. I came into it because I received a call one day from Martin Day. He'd just come back from meeting at the Stanley Hotel in Nairobi with John Nottingham and Caroline, and said, I want you to come and meet this guy. He wants to tell you about a case. And so I came in and chatted, and it was John Nottingham. And he told me that he thought there should be a case against the British government in respect of colonial abuses from 50 years ago. I listened kind of politely and then tried to explain to John why really that was going to be a very difficult case to bring. And John fixed me with a very steely stare and explained to me in no uncertain terms why the case was going to be brought. And anyway, I promised I'd go away and read a copy of a book, which was Caroline's book. And despite being a history graduate and despite having kind of grown up with a kind of a sense of colonialism, got politicized in the anti-apartheid movement in the 80s, I knew nothing about the history in Kenya. And I think having kind of gone through the process of meeting John, reading Caroline's book at the same time that Martin was as well, I think we decided that whatever the prospects of this case were, it was something that we thought had to be brought. But if you'd asked, I think, anybody involved in politics or history or law at the time we were looking at it, is law the perfect mechanism for trying to seek accountability for past human rights abuses and to have accountability and remedies for victims? Most people would have said probably not. And if you said it is tort law, type of law more commonly used for road traffic accidents or accidents at work, the mechanism you're going to use, most people would have thought you were mad. So we had to sort of begin to fashion a case, knowing that it was legally completely novel at that stage, and knowing that it would be fought initially bitterly by the government because of the precedent that it would set. And so in conjunction with the KHRC, the Mau Veterans Association, and Lee Day, the case progressed, and as anticipated, we faced a ferocious response from the government, who advanced two main defences, initial preliminary defences to the case, which formed the basis of two long hearings in the High Court. The first was they said there simply was no case in law, and the main argument that they advanced was that the Crown is divisible. So when you are attacking the actions of the colonial government in Kenya, those are in respect of the Crown in right of Kenya. And so the people who are responsible for those today is a matter of, they say, Kenyan law and also international law of the Kenyan government. So that was the first substantive argument. And then the second substantive argument, the second hearing, was one we obviously anticipated, which is you can't bring personal injury cases outside 3 years, let alone 53 years. We succeeded on that first argument in the first hearing because we just pivoted the case to one of just straightforward negligence of the British government in London. I mean, as Caroline has identified, we picked on certain aspects of the role that London had, distinct from the governor in Kenya, not least the sanctioning of the pipeline system and the control over British forces. And we persuaded the judge that we had an arguable case on that, and we weren't struck out. And it was a pretty remarkable hearing in respect of the first time being able to put into the public domain here evidence of the systemic abuses that London imposed upon thousands of individuals. And then the second hearing was in respect of limitation. And again, we just pivoted our case. So it was, again, not dependent upon proving individual facts as to what happened at individual places at specific times. It was rather all about liability for the systems. And thus our evidence was that you can just do that on the documents that you've got. And insofar as people have died, it doesn't really cause great prejudice. So that's how we put it. And as we know, we won both of those and then moved forward to a settlement process in which, John, you've mentioned compensation for the victims, but also a kind of a core part of the settlement process was not using tort law skills, but was using essentially transitional justice skills to try and make this victim-centric and thus there was real centrality to our approach, the importance of an apology, because as Caroline has mentioned, establishing truth where there have been grave violations of human rights is absolutely essential. And you can see that all over the world where there have been human rights atrocities, victims want truth to be established. So that was really key. And then also as part of it was the building of a memorial, another kind of tool of transitional justice, a memorial in the center of Nairobi that I'm sure Muthoni and I can talk about our experiences at the unveiling of that. So that was how the case went.
Thanks for that, Richard. One of the interesting points you raised there is this idea that you know, transitional justice has to form a core part of the experience of seeking justice for the victims. What are your thoughts on how settling a claim along the way? Yes, there was a large settlement payment made, but the case didn't, for example, progress to a full trial and a judicial finding in relation to the facts, the human rights abuses that formed a core part of the claim. What are your thoughts on whether settlement affects you know, the ability for the victims to achieve full and comprehensive justice? Yes, that's for you, Richard.
Look, it would have been ideal, I think, if we could have had full trials in which all victims who wanted to had a voice, and in which there was a proper full accounting in the public glare of all the aspects of Britain's accountability for what happened. And that would have been incredibly important for victims, but it would also have been incredibly important for this country. And, but court proceedings are really imperfect mechanisms for coming to account to the past. And settlement is one reason for that. I mean, fortunately here, settlement happened after we'd had 2 public hearings, including at the first, where the lead claimants came and gave their evidence, which was an extraordinarily powerful moment. And so it came in the public domain. There were, I mean, this country is dreadful in terms of an understanding as to our past and the role that colonialism played. A myopia and amnesia is almost unforgivable, which underlines the importance of Black History Month. But the one thing we had, although it only kind of touched the surface of public consciousness here, I mean, we had for 4 days in a row editorials in the Times, because Ben McIntyre in the Times really picked up and ran with this story. We have 2 judgments of the High Court, I mean, both in detail, particularly the first one in terms of setting out the evidence, much of it drawn from Caroline's work, played a major role. We had the results in terms of the claimants, and I mean by the claimants all 3,000 plus, feeling a sense of vindication. So we had all of that. So we had something, but was it a perfect mechanism for this country coming to terms with the atrocities that it's responsible for in Kenya? Absolutely not. But was it a moment that allowed that story to come out, that gave voice to victims, that had some degree of accountability? Then yes, compared to other attempts through using law to do that, yeah.
And Muthoni, I suppose this is a question for you. Richard mentions that the law is an imperfect mechanism for seeking justice in situations such as this, where you have victims who have suffered abuses such as this. Obviously, by the time you get to issuing proceedings, a tremendous amount of work has taken place. And just wanted you to reflect on the role of the Human Rights Commission and the amount of effort and the scale of the task that they undertook to get this into shape where it could be turned into a claim that can be run, and in particular, their objectives when you were speaking to the victims at the outset?
There was a huge amount of background work, but I have to say the brunt of it was actually borne by the Mau Mau War Veterans Association themselves. They're the ones who were organized in a network across the country, a representative network. There was no decision made at any point in this case that wasn't discussed with a delegation that came from across the country to the KHRC to hear, sometimes from Dan of Lee Day, sometimes from myself, sometimes from George Marara, my colleague. Okay, this is where we're at. This is what the lawyers are saying. How do you want to move? And they did the job of hearing, of taking it back to their network across the country, consulting and coming forward. In terms of one of the compromises that they made, and actually this is a compromise for which John also had a hard time, John Nottingham had a hard time sort of accepting, was the scope of the case. Initially, they wanted the case to deal with the very fact of colonialism, the fact of massive land removals, particularly from the highlands of Kenya, so-called, White Highlands. So just having to narrow the case down to something which was seizable, even with the difficulties that Richard has described, in terms of here is a violation upon which we can, there's law, however imperfect, to kind of capture it. That was their first compromise, but they took it. Although they never thought that the case was going to be the be-all, end-all of anything. In terms of the background work, they're the ones who helped us identify, once the narrowing down to torture had happened, people whose bodies or mental faculties showed consistency with having been tortured, where there was some physical evidence that could be relied on. At the KHRC, we had to build a database. I think there were 50,000 plus in it by the time we went to court. Every one of those people had to be checked by a doctor, checked by our own counsel within Kenya, with John alongside to sort of read into the details of what they said about where they were picked up, where they were detained, what happened, to sort of make sure in and of itself, each of these 50,000 plus people were credible in terms of what they had gone through. I think that was very hard for the broader mass of Mau Mau to sort of understand, why can't I be in the case? They all wanted to be in the case. And we're like, well, it's had to narrow down. Anyway, so that was a huge amount of work, just getting that database of people up and running. They're the ones who also made the decisions with Dan, with us, on who they wanted the claimants to be. And this is the importance, Richard has spoken to the importance of clarifying history for the UK. This case was so important in terms of clarifying history for Kenyans, because the armed struggle had basically been buried post-independence. Our independence was seized. There were many arms and many different forms of anti-colonial struggle, of which the armed struggle was one. But it had been buried, and sort of, lesser, I would say, more liberal kinds of forms of struggle gained precedence, including a lot of people who had collaborated. So this was really breaking that story within Kenya itself. And the value of this, and I'm coming to how they selected the claimants, was what they wanted to do was to say, our movement was primarily Gikuyu, but we had membership from across the country. And one of our lead claimants is one of the leaders of the Mau Mau War Veterans Association, is very poetic and sort of grandiose as he talks. He was like, we stretch from the coast to Lake Victoria, from Mandera to, And they wanted to prove that and to say, look, the armed struggle and people who participated in Mau Mau were not only Gikuyu. So they made sure that there was a multi-ethnic mix. They also, these elderly people, wanted to point out to Kenyans, younger Kenyans, that women had been full participants in the armed struggle. They didn't just bring food, as important as bringing food is. They paid extremely high prices in terms of sexual violence experience, and they really wanted to bring that forward. And what it takes to come forward and say, I was raped, when you're an old woman of that generation and that time, is really quite extraordinary. Their courage was amazing, but what they got from it, and I think all of us who worked on the case, many times were reduced to tears by the Mau Mau war veterans. You know, the case got so much publicity in Kenya and in the UK. And one of the Mau Mau women, I was sitting with her and she, you know, just started bursting into tears. I think we had just watched a take of a documentary made by a young British woman who sort of accompanied us for quite a long time. And she was crying in the video and also crying outside because she said, you know, my children have never understood why I did this to us, why we live in such poverty, why we have suffered so much. And she said, thank you, because now my children understand. And, you know, as a Kenyan who is an inheritor of what they went through, it was just incredibly moving. So I think the Mau Mau themselves, they were like a public education, conscientizing, decolonizing, and also post, you know, independence. They were breaking a lot of these sort of pervasive and dangerous and ethnic loaded myths and sort of the patriarchy of our country as well. They're extraordinary. They were far more progressive than many people of my own generation. So all of that said, yes, they agreed to limit the case to torture, but they never felt their process with the KHRC was going to be just about this case. Their big issue was land and removal from land, which they wanted to move forward on. And of course, many transitional justice processes were happening within Kenya in that sort of golden moment between 2002 and 2007 when everything broke down. We had a land commission, we had, you know, the task force on setting up the Truth, Justice and Reconciliation Commission. So the hope was that many of these processes would get them justice and reparation in other forms and in addition to what had happened with the case.
Thanks for that, Muthoni. Caroline, I suppose this one's for you. The case obviously was not representative of an isolated incident. That, you know, colonialism was a brutal affair across the board. This was one example of some fairly extreme behavior. What are your thoughts on what the case and others like it raises or reveals about the intersection between European liberalism, which was the virtues that were publicized and promoted by empire, and the contradiction between the brutality of empire and the racial issues, that mix of issues?
Mm-hmm. That's an important question, John. I think you really put your finger on, in some ways, you know, when we think about liberal imperialism, it sounds like an oxymoron, and of course it was. And the question becomes, how does an empire, and we'll say with the British for a minute, because there are some variations between them, but how does an empire like Britain legitimate and re-legitimate this idea of reform whilst at the same time exercising extraordinary coercive measures? And as you're gesturing to, Kenya is not an isolated incident, right? And, you know, and I think if we go back, you know, sort of very briefly, sort of short history lesson, we associate the civilizing mission with all sorts of sort of the markers of liberalism, right? Whether it's, you know, individual liberties, free market, rule of law, and that somehow or another that through the empire, and obviously getting back to all of these famous people, John Stuart Mill and the rest, that these, that the idea was, of course, that, once they encountered empire, liberalism no longer becomes universal because suddenly they're encountering others that are unfamiliar to them. And we see sort of this coming together with sort of ideas, evolutionary ideas, social Darwinism, this whole idea of, yes, you'll get this, but just not quite yet, right? Just not yet. And this idea that the role of British colonialism was to, in fact, to reform, to render civilized those on this sort of spectrum of humanity, with, of course, the white Anglo-Saxon being on the one side and sort of the blackest of Africans being on the other end of the spectrum. We see a change in this ethos, and this is where you have this sort of uncomfortable resting, particularly, and it's not to say that there weren't extreme violence in the trade and enslaved peoples and the rest, but in sort of the mid-19th century, the mutiny in India, the Morant Bay Rebellion in Jamaica, and suddenly we have sort of, liberal thinkers, really pushing the idea that actually coercion is a mechanism and a purpose within the state in how one is going to sort of spread liberal ideas, if you will. And there's a huge amount of debate going on, and we see this playing out. And I'm going to sort of pause here, but my point being that there's both this capacity, what makes liberalism or the British Empire so much more difficult to make the charges of violence stick than, say, the Germans in Southwest Africa or even, the Nazis in Eastern Europe, is it's very clear what that project was, particularly the Hitler's empire. It was fascist. It was clearly fascist. What makes liberalism so hard, or quote unquote liberal imperialism, is that it does have this sort of the slow ability to mete out reform. Right? Even those detention camps were known as rehabilitation sites. So one can say, and we even saw this in various contexts of the case, right? That when charges of violence arose, that there was this, coming down by General Erskine saying, no, this is not who we are, right? We are here for reform. We're here to civilize. And of course, what we know is that this coercive strand is the through line through British imperial history, through the empire. And we can walk our way through, right? We can go from, if we want to go through the 20th century, we can go from the South African War, also known as the Boer War at the turn of the century. We can go to the Irish War of Independence. We can go to Amritsar. We can go to the Arab Revolt in Palestine. We can keep hopscotching through Malaya, Kenya, Cyprus, Aden, Northern Ireland. And the same ideas, the same techniques, the same personnel, genealogically, many of the same people. And in fact, of course, I'm going on and on about this because I'm just finishing a book about this, because once I got done with Kenya, I was, curiously enough, I had the great distinction of having to debate Nigel Farage before he really truly became Nigel Farage on CNN. And, his whole way of contending with this was that Kenya, yes, this happened, terrible things, but let's move on here, nothing to see. And Kenya was a one-off. And to me, what I was interested in, I certainly found this, I'm certainly not going to credit Nigel for my research agenda, but the point is that even in the context of Kenya, understanding the degree to which Malaya was extremely important, which was temporarily contemporaneous to Kenya, it overlapped, to not just the policies and practices, but personnel. And I think for the purposes of this session, one has to understand that there was this intimate relationship between liberalism, violence, and the law. We keep coming back all the time. The British colonial government and will say consistently that we brought rule of law, that what we did was legal. And they created this panoply of structures through emergency regulations and the like, what I call legalized lawlessness. They enabled this behavior, and they rendered it legal and protected from prosecution at the time. And this then begins to intersect with international law, humanitarian law in particular, but also emergent human rights law, particularly in the form of the European Convention on Human Rights. As we know, it's one of the most important instruments because it is also enforceable in various ways. And the ways in which Britain is able to basically institute within international law the permanent state of exception. right? And so the way in which they get around all of these things that we're talking about, detention without trial, et cetera, et cetera. Now, obviously, you're not supposed to be able to derogate, as we all know, for things like torture. However, there's the example of the European Convention on Human Rights. That is Article 15 is the derogation clause. Britain was fundamentally responsible for crafting that law, that article, particularly through the Colonial Office. And of course, in the case, and I'll sort of end here, in the case of Britain, at that time, there was no individual petition. And Britain felt fairly confident in those post-war years that no other European state was going to bring up another European state on charges of having violated these conventions. In fact, that did not prove true. The Greeks brought Britain up on cases both of wrongfully declaring a state of emergency. There were 2 counts and 1 on torture in the case of Cyprus. And what happened there is what we've seen happening elsewhere, and that is on the case of, before this was able, the proceedings were able to go through, they in fact decided to decolonize out of Cyprus, and part of the deal of that decolonization process was that Greece would drop the charges. And so therefore, we never get them actually. There was evidence taken, which was quite damning. But again, getting back to, and in some ways, this, and I'll kick this to the lawyers because I'm no expert, but as an historian who studies this, look, one of the benefits for the British government of settling this case, not only insofar, as Richard was gesturing to, a whole range of things, but one of which is that all this evidence didn't have to come out. Right, all of this evidence, and yes, we had these 2 separate hearings, which are fundamentally important from an historian's perspective. Right, we had the release of the hand-slope disclosures, but remember, those hand-slope. This is where it gets into the nitty-gritty and the weeds of things. Right, that hand-slope disclosure in the process of this, there were many, many documents that we as historians were demanding the release of because they were relevant to the case. It was this game that went back and forth. Right, they would release a few. And then we would say that's not enough. And then we had to present long lists of documents that we wanted. You lawyers know this game, but as a simple-minded academic, I just made my head spin every time I needed documents. We had to go through this process. There were many, many of those document requests that were completely germane to the case that were left unanswered in the course of the settlement. Now, to really get us in the weeds, when they released the Kenyan documents, there was this sort of big show, and I use that term importantly, show of transparency by the British government of releasing all the documents, not just the Kenyan documents, there were 6 other colonies for which they had been holding on to documents for decades under lock and key to the public in the National Archives. What we don't know is how many of the documents that we had access to in the case were actually released to the public. Because what they did is they changed the reference number. We had date stamps numbers and they had the old reference numbers from the colonial files. They created an entirely new set of reference numbers for the National Archives. So unless I paid a bunch of folks to go in there and literally go through file by file, do you see what I'm saying? So my point is that when we get back to how do we write history, these documents are extremely important and it becomes a document and evidentiary game. And the cases become extremely important for us as historians because of the release of more evidence and the ways in which both in the present and in the past, the processes by which the British government went to conceal evidence is extremely important. And of course, those processes don't change. Again, another through line is concealment of evidence and cover up. And so getting back to your initial question about the relationship between liberalism and imperialism and the like, one has to see that what's so challenging with liberal imperialism is it both illuminates, right? Release all the documents, we're transparent, and obfuscates at the same time. It's both. And so that's why in the British Empire, when we talk about systematic, racism, all the things present today, every time you make a charge, somebody can hold up something else, right? We led abolition, we can go back, we can tick off all those sorts of things. So then it becomes a forensic process of showing how that's not correct. And that's where I think one of the beauties of this case from just the intellectual standpoint is the way in which historians and lawyers came together to take that sort of forensic charge of putting history back together, of establishing truth, and then establishing that in the courtroom. And that we have rarely seen in the context of the British Empire. In fact, this is probably the only case that I'm aware of, even if there was other false starts, as in the case of Cyprus. Thank
you. Richard, coming back to you, I know you've described it as the band getting back together, but I think one of the common themes that runs through all of the points that the other panelists have made, and you as well, is that there was there were a number of unique aspects to this case that came together. For example, John Nottingham's involvement and interest in driving this forward, the efforts that the Mau Mau Veterans Association made in the background in building the case and finding the victims. Caroline's research on the book. Do you think this is an example of something that was essentially a perfect storm, and therefore it was able to generate justice for the victims? Or can the law be used in this manner or in a different manner to achieve justice for victims of colonial justice?
That's a really interesting question in terms of what makes things happen. Can I kind of answer it in two potentially contradictory ways? I mean, the first is, take the second part of your question, is law definitely can be used and is an essential component in any framework of rule of law to address wrongs, whether they're human rights wrongs or any forms of wrongs, right? You have to have a legal framework to do that, whether you look at that on a domestic level or in terms of the international order. It can be a very ineffective means of doing that. There are, compared to activism or journalism or other mechanisms of setting out history, raising public consciousness, it's often ineffective. But so the answer to your broad question is, it can address some, but not by any means all legal wrongs. In terms of why this case happened, when it happened, I mean, I think there was a large degree of serendipity. I mean, you're right. The decriminalisation of the Mau Mau, the change in the position on the ground in Kenya, at the same time that Caroline's book came out, David's book came out. It's happened at the same time that there was a increasing prominence of enforcement of human rights within the English courts. As well, a whole beginning of a whole new wave of cases in which English courts were being used for in respect of accountability of human rights overseas. So all kind of that kind of moment as to why it happened. But there, as I said, law is a really crude framework for dealing with, I mean, just see how few human rights cases there are compared to the amount of human rights abuses there have been. And you can kind of, it is, of course, you can take things from this case and apply them and say it can work in other cases. And indeed, there have been some other kind of successful cases. Sophocles was a case that settled in respect of not dissimilar accusations in respect to Cyprus, including some of the same individuals who were hooked up in Kenya. But there are others in which it's just fallen flat. I mean, there was, after this case, an attempt to, well, there was a case that went for about 2 years in the Queen's Bench Division, full-blown trial on behalf of Mau Mau veterans that completely failed. I mean, it was a very different case, the one that we brought. So I'm afraid your answer to your question is kind of yes, no, yes, but.
Thank you. Muthoni, this is a question for you, really. What are your thoughts on how a fuller narrative around Britain's colonial history and investigating the true nature of that history, how do you think that process can reframe the conversation around issues such as government aid in Africa or development financing or trade and investment in Africa?
So I guess I will begin by sort of saying there are different forms of knowledge, right? And I think for many Kenyans who lived through the emergency, lived through colonialism, they didn't need proof of what happened because they were that proof. Their lives were that proof. And I think Carolyn will probably speak to it, but some of the debate around her book was that she was giving credence to people's own stories of their own lives, legitimizing them in a way. So I think there's a question around, or something that we need to take from this about respect for people's subjective experiential knowledge, and a questioning of why it is this, torturous process that Carolyn described and Richard described of proving something happened and then getting that acknowledgement in court needs to happen before, in this day and age that we still have to put people through that instead of just being, that's a terrible story, I'm so sorry, which should be a normal, you would think, a normal kind of experience. So that's one thing I would say. The second thing I would say, now I've lost my train of thought. Just repeat the question again. Sorry.
I was interested in your thoughts on how having a true narrative about British colonial history will affect conversations around.
Right. Yeah. Okay. So there is that. And I think when you talk about restitution, whether for slavery, whether for colonialism, I mean, it's like an impervious wall. It's like, what are you talking about? I mean, you can look at the laws and the sort of negotiations that happened at the end of independence in almost every colony, where compensation had to be paid, not just for land seized, but expected profits on those lands for about 10 years. I mean, ridiculous sort of legal things that were put in place to completely justify and perpetuate dominance and exploitation. There is, of course, there's a groundswell of action across the country and across the world. And it's come and gone. I mean, I think if you think back to the days and the organizing around the UN World Conference Against Racism, you saw these sort of restitution, reparations movements from around the world, not just of Africa, of African Americans or Afro-descendants in North, South America, but also of indigenous people around the world who really sort of came together to make that case and try and put forward a platform for recognition, restitution, and so on. Then it died away. Of course, this summer, we've all lived through Black Lives Matter. I mean, globally, decolonize. So I think we're at a point in time where these questions are on the table again. That said, there is a huge disconnect between those movements and, on the one hand, the domestic environments that they're trying to shape, be those domestic environments the UK, the US, or whatever. There's an even further remove when it comes to the foreign policy of those countries, of UK, of US, or whatever. If you talk to any foreign policy person on questions of would you equate, ODA, FDI as a form of reparations, they'd look at you as if you're out of your mind. There's no decolonize within foreign policy spaces yet. But I think that's probably the next sort of stage of the battle, is really beginning to make that case. And I think in terms of the groundswell of popular protests and movements, it's there. Of course, people's first demands are where they live, but it should also, and I hope it will also, come to what countries that assert themselves globally and in the multilateral sphere also have to account for in that sphere.
Thank you. Just one final thing that I wanted to touch on before we close, and I think it's an important one, which is the experience that you had after the case both you, Muthoni, and Richard touched on this earlier in relation to the unveiling of the statue, and obviously your interactions with all of the veterans and the survivors at that event. We could hear briefly from you, Muthoni, on that experience.
I mean, I think I've spoken already about how many points in the process were so moving, you know, spending all that time with John, spending all the time with the veterans, learning about history from people who lived it. I mean, there were many times that we were reduced to tears. But because we had been doing the organizing on the ground, meeting with the veterans, sort of traveling around the country to sort of talk to them and so on, I don't think I was as surprised as perhaps Richard and Philippa were, and Dan and, you know, the team from Martin Day when they arrived. Because of course they knew they were working with 5 claimants who were representative. I think they had no idea how many claimants they were working for or how many people they represented. But I'll let Richard speak to that.
Yeah. I've got 2 takeaways from that. I mean, the first is like just on a purely selfish perspective, which is, as Muthoni said, I pitched up to Nairobi thinking there were going to sort of be, you know, a couple of dozen people politely clapping as the monument is unveiled, and then half a dozen people, politicians, claiming credit for things they had absolutely no role in. And I was right about that last bit, but what I wasn't right about was turning up in the park, and there were just thousands and thousands of people, and it was this enormous celebration. And from a purely selfish perspective, having kind of, you know, it was the most remarkable experience doing this case in court. And normally, you know, I do lots of human rights cases and you get judgments and then you see some of your clients afterwards, and that's great. But this was like nothing else I've ever been part of. It was just phenomenal to be there. The second part that I took from it, though, is just, you know, I've been really interested in transitional justice for a long time, having been involved in human rights. And actually just to see in real time the importance to victims of mechanisms for establishing truth and that things happened, and monuments being an incredibly powerful sense of that, and just having this extraordinary privilege of watching the victims see the monument and take in the moment was, I mean, I am getting emotional just recalling it now. It was truly extraordinary.
Thank you. Well, I suppose all that's left is to thank all 3 of the panelists. Thank you so much. It's been a real privilege to hear you tell your stories about your experiences and to hear your thoughts on these ideas. This series for us is the beginning, and we hope it's the starting point for ongoing conversations about these really important issues and hopefully practical engagement about these issues. So thank you so much, Richard. Thank you, Muthoni, and thank you, Caroline, for joining us today.